chance to meet today. I'm Darrell Clay. I'm the 2017-2018 president of the Cleveland Metropolitan Bar Association. There's 7.5 months left to go, and then it's Marley's job, who just stepped out to get some lunch. So, right, nobody's counting. So we are on Facebook Live today. We want this to be interactive. So if you do have a question, keep your voice up so it can be picked up on the microphone. We have two great speakers here today to talk with us about what's really a hot button issue right now in the American consciousness, and that is freedom of speech, and in particular, freedom of speech in your workplace. So we have with us, Elizabeth Bonham, who is a staff attorney at the American Civil Liberties Union, a graduate of Warren Wilson College, and a very distinguished graduate of Cleveland Marshall College of Law. Also contributing to her credentials to speak on free speech are her passion for gardening. So if you have questions on that, please be sure to see Elizabeth afterwards. No less distinguished is former CMBA President Bruce Heery. We won't accuse him of being a captive of management while he's up here. That would be true at all? No. Bruce is a graduate of Fordham Law School, Wesleyan College, and practices with the national firm of Ogletree Deakins in the areas of employment, restrictive covenant, trade secret litigation. Have I missed anything, Bruce? Okay, all right, thank you. So we want to talk about freedom of speech in the workplace. We all know the First Amendment says that Congress shall make no law abridging free speech. And it was in 1891 that no less than Oliver Wendell Holmes said that an employee may have a constitutional right to talk politics, but he has no constitutional right to be employed. So I thought that was an appropriate place to ask Elizabeth or Bruce to just give us sort of, what's the rubric when the First Amendment says Congress shall make no law? What does that mean for my employer?
So he stole my first joke. I just want to correct one thing in the introduction. I didn't go to Wesleyan College. I went to Wesleyan University. And that's important because I was in Denver this weekend, and some of you who've been to Colorado know that the governor there, Hickenlooper, is a big champion of marijuana laws in the workplace. And if you were at Wesleyan when I was at Wesleyan, it's no secret why the governor of Colorado is such a big supporter of marijuana laws. This is obviously an important issue, and it's timely. I don't think it's entirely new. Certainly in terms of athletic protest, you can go back to the 1968 Olympics with Tommy Smith and John Carlos and the clenched fist. People seem to have forgotten about it, but in the mid-90s, there was a young NBA player named Chris Jackson who had become a Muslim and changed his name to Mahmoud Abdul Rauf. And he didn't believe that the national anthem was consistent with his religion. Thought it was too much of a worshiping and didn't have anything to do with Allah. So he would sit out the anthem, and it was controversial at the time. This is back in the mid-90s. A side note, I used to represent the Cleveland Cavaliers much more than I do now when the former owners owned the company. And I was downstairs when the Boston Celtics were in town, and there was we can call him an old school NBA player named Cornbread Maxwell. His first name was Cedric Cornbread Maxwell. And he was there literally making fun of Mahmoud Abdul Rauf's name, and he just kept repeating it over to himself because he couldn't really appreciate that anybody would have that name. Anyway, Mahmoud Abdul Rauf was vilified for refusing to stand to the anthem. His NBA career pretty much tanked, even though he was an extremely talented player, an All-American at LSU. He wound up having to play overseas and never really played in the NBA again. So this is not, it's not new, but it seems to have greater import now because there are so many examples of people saying things that can potentially get them in trouble with their employer. You may want to call your boss a moron. That can get you into trouble, even if you deny it. As I was walking in here, there was a crawl about the relief pitcher for the New York Yankees, Aroldis Chapman, who apparently called the manager of the Yankees several nights ago, when things looked better, when he called him an imbecile. I think both of these appellations, the moron and the imbecile, had adjectives in front of them, which weren't on the crawl. So it's not a new thing. And as far as an employer is concerned, there are certain things you're allowed to say in the workplace, certain things you're allowed to talk about, but there are certainly other things that are going to get you in trouble and get you fired. All of us, I think, can think of examples where things we may have said or expressed under our First Amendment rights, even though we have the right to say it, may have potentially got us into trouble. I remember a time in 1992, in the summer of 1992, I had just finished playing golf with a client of mine whose politics I didn't know and didn't appreciate. And when we finished the round, he said, rather than taking our clubs to the clubhouse, I'll just drive them right to your car. And I said, okay, well, that's nice. We go right to my car. As we approached the back of my car, he screeches to a halt. He jumps out of the car and he goes, somebody's vandalized your car. And I said, what are you talking about? And he says, you have a Clinton bumper sticker on the back of your car. And I said, it's not vandalism. That's mine. And he goes, he was shocked. His jaw dropped. He said, you seem so intelligent. I can't say that cost me business, but my guess is it did. It didn't cost me my job, but it cost me business. We also have now issues involving Facebook. I am on Facebook, but I never post anything. I rarely comment, but I am shocked, I tell you, at what my colleagues do. I have colleagues from around the country and what they post on Facebook, personal stuff, political stuff. I'm amazed that they either have the courage or the stupidity to do that. But it's part of our world, I think. I'll tell you one Facebook story and then I'll shut up for now. I have a client, and a employee one day heard a rumor that a supervisor she could not stand had been fired. Turned out the rumor wasn't true, but she assumed that this supervisor that she hated had been fired. And so she posted in rather exultant terms. It started out ding dong, the witch is dead, something like that, and then it got worse from there. And she then put in rather graphic terms about how happy she was, talking in terms of what she would rather have done to her than have to work for this really awful stuff, she says, about this supervisor. Co-workers of her pick up on this thing, this posting, and it causes a major disruption in the department. So the HR people investigate, and they confront this lady and say, did you post this? First of all, it's untrue, and second of all, it's outrageous. Did you post this thing on Facebook? Her response was, somebody's been hacking into my Facebook account, and they hacked into it again. I would never say that. In fact, I am upset that you would even suggest I would say something like that. It's outrageous. So we said, okay, fine. We'll just continue our investigation. Sure enough, coworkers of her came into us and said, not only did she do it, she was bragging about having done it. And so we fired her, not for posting it, but for lying about it. She filed a lawsuit, claimed her First Amendment rights have been abridged. It was knocked out on summary judgment in federal court. And so it is true that you do have a constitutional right to talk. You don't have a constitutional right to have a job. So with that.
Thanks. So I can, we're not using this, right?
I don't know.
So I can talk a little bit, I'm from the ACLU, and so what we do is free speech, what we do is government action. So that's where a really interesting part of this conversation comes up for me, is that a lot of people right now are talking about, are throwing around the term free speech. And I get a little nervous when we're bandying about that term, because I think often we're doing that and we're not recognizing that we're not talking about state action at all. So when you are in an employment situation and you're working for a government entity, it could be a public school district, you don't have to be, a district attorney, but when you're working for any public entity, you have certain free speech rights, and I'll tell you a little bit about a cause of action that you have in that situation. When you're working for a private entity, you have no free speech rights in that situation. I mean, you don't have a cause of action unless there's some, in some circumstances there are state or local laws that create a free speech right for you that you could try and recover under. Of course, there's some labor laws or some contractual terms that you might have a cause of action under, but you don't have a cause of action under the U.S. Constitution. And the reason that I think that's important is because now, we have NFL players kneeling during the anthem, and we have a lot of conversation about this. And people are going, oh, it's free speech, it's free speech. Well, it's not really. It's maybe a value that we have about public discourse. It's maybe something that we feel in our political philosophy as people in the United States that's very important to us. But it's not free speech as Congress intended it, in the part of the amendment that you read. So some of the work we do in the employment context, when you're talking about a free speech claim, what you're really talking about is a retaliation claim, right? So somebody was engaged in constitutionally protected activity. In this case, we're going to be talking about free speech. Their employer took some action that would cause them to stop, or a reasonable person to stop engaging in that activity. And that action was at least partially motivated by what that person was doing, that protected activity. And so within that retaliation claim in the employment context, the test we use to evaluate that is known as the Pickering test. And what it basically says is an employee, if they're talking about a matter of public concern, and I think it's often pretty easy to meet that public concern test, right? When people really care about this and care about bringing a cause of action, maybe they're talking about, social justice issues. Maybe they're saying something really vile, but it's a matter of their political belief. So it's a matter of public concern. And then you weigh out that person's interest in that protected speech and in bringing up that conversation against the employer's interest in disciplining them or shutting that conversation down in the workplace. There's another case called Garcetti, and it sort of modifies that test. You are not allowed to be talking about something if it's directly pursuant to your job duties. Okay, so that's sort of an exception that we can treat separately. But as a general principle, if you're employed by a public employer and you're talking about a matter of public concern, it's important to you, it's important to the public discourse. It's our position, usually as the plaintiff side free speech people, that that employer is going to have a pretty high burden to show that you're really disrupting something in the workplace. Otherwise, you get to say what you're going to say. So we've handled a couple of cases like this in the past couple of years. Speaking of Facebook, we handled a case in the Green City School District. This is sort of a farming town, and our client was a vegan public school teacher who was posting on his Facebook account, don't buy dairy milk, and here are photos of local folks that are producing dairy milk, and here's how evil that is. And the school board, which was really populated by folks that had an interest in the dairy market there, didn't like that, and so they fired him. In another instance, we had a school teacher in Sylvania Schools by Toledo making Facebook posts about Black Lives Matter and calling out some of the actually in-school aggression towards Black and brown kids in schools and from school resource officers, and the school really didn't like that. You might have a little bit of a closer call in a situation like that. That's about what's happening in school. He's a school teacher. There's a relationship there. But unless the school district or the public employer in general can show that that person was really disrupting the environment, or that person really didn't have an interest in talking about what he was talking about, they can't retaliate against him. They can't fire him for exercising his right. So that's in the public context, right? Much of what we're seeing, I think, right now, and I think it's bringing up these free speechy feelings for us, but it's mostly in the private context. We have the Google memo. That was a private employer. We have, I don't know if folks saw this, but after the horrible events in Charlottesville, one of the white supremacist millennials that was marching in Charlottesville that was pictured carrying those tiki torches resigned after a conversation from his position at a hot dog shop in Berkeley. And those companies have a right to do that, and I think it's important to think about, because the ACLU really does stand for a free and open society where we can have a marketplace of ideas. At the same time, recognizing that in private spaces, those can be spaces where we get to model how we want the world to look, and we get to stand for the kind of culture that we want to create. And so that's an interesting balance, but that's a line that I would draw. We can talk more about that.
It sounds like, in broadly speaking, if I'm an employee of a public employer, I've got much broader rights than private employees.
I think that's generally right in terms of speech. You know, Title VII is different, you know, the way that you identify is different, and so on.
Can you talk a little bit about how that analysis is impacted, if at all, if the private employer happens to be unionized?
Well, even if you're not unionized, the National Labor Relations Board will get excited about allowing free speech that has to do with quote unquote terms and conditions of employment, or if they feel it's concerted activity where you are trying to talk to your fellow workers in a communal way about issues in the workplace. And the NLRB has gotten, as kind of union membership has kind of gone down in this country, the NLRB has actually gotten more aggressive about trying to administer what's going on in non-union workplaces. So if an employee posts something that arguably is talking about terms and conditions of employment, and that is one of the arguments that the guy who wrote the Google memo, which was a very self-critical and, in his view, honest appraisal of their hiring and their practices having to do with gender. He got fired for it, but I don't think that issue is dead in terms of what rights he may have to having expressed those views. But the NLRB, if you're talking about terms and conditions of employment, I mean, if you just put something on Facebook, this company stinks, they don't pay enough money, we're all underpaid, you know, that is probably protected, not necessarily under your First Amendment rights, but it's probably protected under the NLRA. So, I mean, the workplace has really changed in terms of the culture because of social media and the fact that people are working harder. This isn't an original thought of mine. In fact, I read about it. But because we're working longer, we don't talk at work as much about issues of common interest. I was shocked when I came to work on the Monday after the Las Vegas shootings. Not one employee mentioned what had happened the night before. And I don't think that would have been true 20 or 30 years ago. But there are so many outlets where people are talking about it on Facebook or posting pictures on Instagram or whatever. It's kind of replaced the traditional, we don't have water coolers anymore. So there are fewer opportunities, I think, for employees to express themselves, and it's harder. So in some senses, I think employers should be more sympathetic when employees feel a need to vent on social media, because I think it's important for our democracy that we be able to hear different views. Yes, and it's done all the time. That's what was, I mean, the suspension of the woman at ESPN who just tweeted about the owner of the Dallas Cowboys and his threat that he's going to, you know, bench anybody who protests, which would be really interesting if everybody protested. Frankly, if he benched the whole team, that'd be interesting. And she weighed in and tweeted that was putting inappropriate pressure on African American athletes who could be considered sellouts if they didn't protest. And she then suggested that, you know, they should go after the advertisers and not the players. And then she tweeted that she wasn't talking about an NFL boycott. Anyway, ESPN made it very clear. They had reprimanded her a couple of weeks ago. This time they suspended her because they made it very clear, look, ESPN is a sports station. We're not a political station. This is not in the best interest of ESPN. It's a violation of our code of conduct. And she's been suspended, and I expect it'll be upheld. even though she can say, hey, I have First Amendment rights. Well, you do, but as Oliver Wendell Holmes said, you don't have a right to be employed.
Not as a constitution matter, no. No, and and I would say we have free speech rights in other areas, right? If she's unfortunately out of the job, then she has an opportunity to make her voice heard in other ways if this is a really important issue to her. And but no, not as a constitutional matter of employment.
Right, so let's get to the big question: does Jerry Jones have the right to tell those players they have to stand for the national anthem?
I would say he has the right. I think it would be ill-advised. I think it would contradict what the commissioner has said and what another representative of the owners has said. I think if there was less talk about it, it wouldn't be that big a deal. I mean, I didn't know this, but apparently this playing in the national anthem at NFL games is a relatively recent phenomenon. It's only been in the last 10 years they've done this. I mean, I think we could all wonder, why do we play national anthems at sporting events? I mean, I go to the Cleveland Orchestra on occasion. They don't play the national anthem at the beginning. There's 2,000 people there. I mean, what is it about sports that makes patriotism important? And you're championing patriotism by requiring people to stand, and yet people who are exercising their First Amendment rights somehow are unpatriotic about, all of a sudden dissent has become unpatriotic, which I think is unfortunate.
Always national anthem played beforehand. Always all players out on the field. Everybody stands.
That never happened when I played all sorts of college sports back in the 60s and 70s. The national anthem was never played before a college sporting event. Somehow I was shocked to find out. I asked a receptionist in my office. Admittedly, I haven't been in an elementary school for some time, but I was surprised to find out that they still require kids to stand up and say the Pledge of Allegiance. Everybody know that? I didn't know that. They still do that. I mean, I got a kick out of people reacting to the anthem issue in the NFL saying, well, if I did that at work, I'd get fired. Well, I don't know what job you're in, but they don't play the national anthem when I come to work. Kind of bizarre.
And with regard to, I think the NFL players, right? They're uniquely positioned to be making this statement. I do think that it's important. It would be a much less effective statement to make if they weren't making it during the national anthem. This is something you hear now. Well, why do they have to do it then? And of course, it's because the goal is to demonstrate that there's something wrong in the nation. So it's actually a very effective time to do that, and they're on a platform where many, many people are watching them. And so I think in terms of a protest, this has been a very effective way to get this conversation going, this necessary conversation going. I think that their private employer can say, cut it out. Now that we're at the point where we see kids in high schools and middle schools and public school modeling this behavior and joining in this protest, that's a different story when you're in a public school. And so if you small pitch look at our Twitter feed, we have asked folks to reach out if they're being disciplined at school for this, which I don't think that they can be.
I'm actually the same thing.
Yeah, I should mention, I think it's instructive that you see the difference in how the NBA handles it from the NFL. And I think they have different markets, understandably. They have different players. But the NBA has been much more relaxed about allowing players to protest, whether it's LeBron wearing a I Can't Breathe t-shirt with that poor fellow Garner who got strangled to death, or other protests by NBA players. The NBA is a much more hands-off organization. They allow coaches. I mean, NBA coaches from Steve Kerr to Greg Popovich to others have been extremely vocal and critical of political administration's protests. And the NBA is much more relaxed about it, much more liberal. And as a result, I think it's much less controversial. I think the NFL has kind of maximized the controversy out of this, which in essence really isn't that big a deal. But I mean, it's not like, it's not like the players are turning around and mooning the flag or anything like that. I mean, it's a pretty dignified thing they're doing. They're kneeling. And you would make an argument that it's not much different than standing, but I don't know. People are all excited about it. Yes.
His fellow employees or ABC company employees, let's support so-and-so for mayor. Okay?
Yeah.
And of course, the owner of the company says, I don't know, you're fired. Now, with that, under those circumstances, you have protected activity because of the subject matter.
I would say no, because I don't think it involves. Now, if they said because this mayor is going to do something, it's going to benefit our company because he's going to, champion some redevelopment project that's going to create more job security for us, something like that. But just to support a mayor with no connection to the business, I wouldn't say that was sufficiently related to the terms and conditions of the business. Yeah. Oh yeah. Absolutely.
And again, you see to organize his fellow employees to support this mayor.
Yeah, it's concerted activity, but it doesn't really have to do with their workplace. And there has to be that connection. Yeah, Mark?
Question for both. It seems to me there are some instances where the relationship between the state action, and private employers is more complicated than just public employee, private employee. I'll give you 2 examples. One, some years ago, when I was employed by a large law firm in town, I wrote an op-ed piece in the Cleveland Plain suggesting that Northern Ohio ought to secede from the rest of the state because I was tired of being trapped with all of the Southern Ohio blankety blanks.
It was a very good piece.
It got a lot of attention.
Yeah,
At the time, the Speaker of the House, a fellow named Larry Householder, got offended by this and called up one of my colleagues in our Columbus office at the time to protest, and tried to see if he could bring management down on my head about this. Now, if I had been discharged for that, obviously management has a right to do whatever they want, but the question is, does Larry Householder have a right to interfere with private employment because of exercise of free speech? Or for a second example, suppose the President of the United States were to call on an NFL owners to fire players who are protesting. Do they have a cause of action against him or against the government for interfering with their free speech rights? But now you have state action for private employees.
I don't know the answer to that.
I don't either, and I've been thinking about this because that's now the favorite question that people ask me at dinner parties: is the President of the United States, talking about this NFL thing actionable? I don't know if we could make you a cause of action against that state senator, but it's something I'd like to think about.
Okay. Yeah, because it kind of is an intrusion into the private, but
it's
you're not a public
the chain
employee.
is fairly removed,
Yeah. But I give you a lot of credit for doing that. I often have ideas for op-ed. I've been doing what I do for a long time, and anyway, I have to be careful what I say. And so there is a time when I retire when I will feel a certain freedom to say things about what I do, and what I do has become over the years, that I'd love to write about, but I can't do it now because that would be stupid. So, yes.
First of all, a point, there's an NFL Players Union. So
There
one would
is.
think that if an owner decided to fire NFL players, first of all, that's stupid, but secondly, that would breach a contract, I think. So I've heard somebody wonder whether or not the president believes that these owners own these players, but that's a whole other thing. But the question about the private and public mix, I mean, sometimes you get, in constitutional law, you get into a question of, you've got a quasi-public employer. Let's say there's there's, federal funding for a private contractor to do something, how does that change the analysis?
Well, when you mentioned that, I don't know how it changed the analysis, but when you mentioned that, I immediately went to a university who may be getting federal funding for financial aid or something like that. And then you also have this overlapping issue of academic freedom of professors and what they can say. So I agree that's a different, brings in a different element to it.
Let's say a private prison, for instance.
Yeah.
That's running the prison for the government.
Wow.
Yeah, I mean, I think that you have a really good argument that prison is basically standing in the shoes of the state and holding itself out to be the state. And there's case law about the state can't actually get away from a cause of action by just simply contracting out private service providers in the medical context and in the prison context specifically, which we're really concerned about, with increasing privatization. And in some circumstances that's limited. For example, there's a lot of entanglement between federal funding or state funding and public schools, through voucher programs. That's got sort of a special jurisprudence. It's very hard to show state action in that context. But in other contexts, basically, I think the question is the entity basically an agent of the state or holding itself out to be an agent of the state? And then there is another scenario where there's the problem is actually with the funding link. So this is happening, not to bring a total lightning rod into this conversation, but there are these bills that are popular now that the ACLU has worked on in various states where the Congress will say, we won't give state contracts or will obstruct contracts with entities if they participate in boycotts of Israel. And so when state funding is conditioned on terms that would obstruct your constitutional rights, that's another scenario where there would be state action.
I think it's also important to mention that there are other protections for employees who say certain things. I mean, it would seem to me, for example, using this ESPN female, now she's a black female. Now, she had evidence that, wait a minute, a white male guy over here said stuff, and you didn't do anything about it. Whether it's a free speech or not, she would probably have a discrimination claim. There's also, so there's protections on stuff that's, related to certain protected categories. There's also whistleblower protections. If you're going to, criticize your employer, in a relatively formal way or informal way because they're doing something illegal, as long as you're pretty confident, and you formalize that under the whistleblower statutes, that would be protected too. So I don't think employees are totally without ammunition.
And I actually think you can, there are some instances where you can start, you can experience retaliation, and it's like the idea is that it's about your speech, but it's really a proxy for your race or your gender or your sexuality. And that's an important thing to think about.
So does it matter if it's your speech versus someone with expressive activity in the workplace, as opposed to talking about my politics? If I choose to wear some organization that is antagonistic to me, is that matter in the analysis? That it's not it's pure speech versus expressing activity?
I wouldn't think so. I would think if you were wearing some kind of controversial T-shirt, it might be a violation of the dress code. But if you, I don't know, hung a poster in your office that suggested something controversial that your employer wasn't crazy about. I was interested to read about one case where I think a community college instructor was invited to be a guest on Tucker Carlson. Why anybody would go on that show, I don't know, because it's not a conversation. It's just Tucker Carlson outbeating him about his own views. But anyway, this guy came on and was talking sympathetically about the Black Lives Matter movement, and whoever his employer was thought that was inappropriate and terminated. So, but I don't think it matters whether it's symbolic speech, gestures.
Doesn't matter. Yeah, generally speaking.
Equally
start doing
protected or
something-
not protected.
Right, not protected. It's the
Yeah.
same test.
Does anybody play the national anthem before they start work?
We do.
We're
Just,
implementing that.
You are? Well, that
We're
would,
going to, except nobody's actually.
that would make sense.
sure, I can talk a little bit about that. So for us, it's important to make the distinction between free speech. You know, that's a term of art. That's a constitutional term. When you're talking about free speech, you're talking about the government suppressing something that you have the right to express. When we talk about hate speech, that's not a term of art. To me, there are a lot of different ways that we can quantify that. And it doesn't really have to do with whether the speech is protected. So from my perspective, you know, there are a couple narrow categories of speech and expression that are not protected. If you're threatening someone, if it's a really particular, direct, true threat, if you're really about to commit a violent act, if you're saying words that actually that actually have the effect of action. And those are really narrow circumstances. It's the ACLU's position that short of that, almost everything is protected speech. When we talk about hate speech, though, we're talking about something else, I think. We're talking about words that actually can hurt you. And whether or not they're protected, you know, it's also part of the ACLU's position that we should address that and we should be shutting it down in our activism and in our other work. And so that's hard to do, to hold those two things at the same time, right? I think what helps me think about it is when we're talking about free speech, we're talking about the government. The reason that we're concerned about free speech is because the government is uniquely positioned to censor all of us. And that's what we're worried about. We're worried about the state actor because it's got such power of censorship. When we talk with each other, we don't have that same kind of power. I mean, certainly there are power dynamics depending on your race and class and stature and age and whatever. But because we are protecting free speech so that we can get away from government censorship, then we have the opportunity to, with each other, address and shut down hate speech and try and move forward. And so that's how I like to think about that. I don't know if it's helpful.
Ellen?
Having said what you just said, how can the ACLU explain what they did in Skopje one night when the Ku Klux Klan or the Nazi Party attempted to march in March with the ACLU's protection? It's, I mean, again, I know you did go into detail to that between hate speech and that, but surely there was, and if you can say that symbols can be as protected or not protected as words, surely that was a symbol that could cause real problems, especially where it was held.
Absolutely, right. And if folks aren't familiar, I mean, I think when you say where it was held, there were Holocaust survivors. This place was selected because these evil people wanted to go and you know, march and basically further oppress and wound this particular community that they targeted. And so the ACLU's position there in defending their right to march was the position that the government doesn't get to decide who may and may not have a march, provided that it's peaceful. And we can talk about, you know, the limits of peaceful and whether we really think that's peaceful. And I think that's open for discussion. But, you know, whether there's no actual, if there's no actual threat of violence, then the ACLU's position is that the government can't decide who gets to march based on the content of what they're saying, even if it is that hurtful. And I think, you know, we talk about Skopje a lot at our organization, and I think that it's important. What we see now, I think, because now there are people my age, there are millennials, like we saw in Charlottesville, that think it's like hip and edgy to be neo-Nazis. And they go down to a place like Charlottesville with torches, or they go out to Berkeley armed to the teeth. Is that peaceful? I think that's really getting to the outer limits of what you can possibly call peaceful. And so maybe we should be reevaluating that determination. The important thing for us is that the government isn't the one that gets to decide.
So you're suggesting the ACLU will protect anybody who might come out of hateful speech.
Out and out hateful
speech.
Hateful speech.
Because, and not, just what they say rather than what may happen. You know, obviously, they would protect them. I mean, believe me, I'm an ACLU, was a very much of a strong ACL supporter. I made my annual contribution, but that turned me off.
Sure.
To be honest with you, because it affected me personally.
Well, you know, let me be honest. It's turned a lot of us off inside the organization because of how difficult it is. And I don't think that anyone that works at the organization would say that it's easy. You know, there are, you know, at various levels, I had to come out in the press before all of my friends in the LGBT community that I'm a member of and defend someone who was saying that he hoped Columbus Pride turned out like the Boston Marathon because all of us needed to be exiled to an island. You know, there's a lot of pain around the Skokie case still. There's a lot of pain that's very fresh around Charlottesville. It's always been our position that when there's not an immediate threat of violence, what we're here for is to make sure the government doesn't get to be the one that decides whose message is allowed to be heard in the public sphere. We stand by that, and at the same time, we're being very intentional about re-upping our work to counteract that kind of hateful speech and those kinds of hateful attitudes. And so what we do now, I think, is we show up on the other side of the protest line. You can make sure those people get their permit from the government, and then you can go out and tell them how wrong they are. And we're working through that every day.
I think you could argue that there has been an erosion of free speech rights because people are extremely sensitive. And I've been surprised recently about, especially what's going on in college campuses, about how intolerant certain so-called liberal colleges and universities have gotten student bodies who can't tolerate dissident views on campus, and to the point of protest, violence. I mean, when I went to college, the idea of going to college was to get exposed to different viewpoints, not to just hear the same viewpoint. But it seems like on today's college campuses, there's a trend toward only hearing what you feel comfortable hearing. And I'm not a college professor or a college administrator, but I think I'd be concerned about that. I don't know if you guys have observed that on your campus.
I wanted to ask respond about isn't the ACLU really rethinking its position on that? Because I heard that in the aftermath of Charlottesville, especially when protesters are armed to the teeth, the ACLU released at least one PR saying that they will not defend anymore that right if they feel that the right to free speech is curtailed, that basically the people's threatening demeanor that does not allow any meaningful exchange in the marketplace of ideas.
Yeah, I mean, I think that's right, and I think that's really always been our position. We're, like I said, sort of re-upping it because we're having such deep internal reflection after Charlottesville. But that when you go into the middle of the public square armed to the teeth, or the middle of someone's public college campus armed to the teeth, can that really be called peaceful expression? You know, I think certainly we're going to have to feel very confident that a group that we represent intends to be peaceful before we represent them.
I have a question. The Garcetti case specifically states that if a public employer has other means of limiting a public employee's speech, such as implementing social policy or social media policies and other policies about speaking on their employer. Now, what happens when you have a public employee who is speaking on a matter of public concern outside of her official job duties, and her interests clearly outweigh the employer's interests in potential destruction within the employer. But her speech violates that social media policy or violates whatever policy that that employer has in place.
That's a good question. So, you know, I think in the situation that you enunciated, Garcetti's not a problem, and you've got protected speech. Right, Garcetti only is a bar when the person is talking directly pursuant to their job duties.
Right.
And there's been some case law, including in the Sixth Circuit, that sort of even has limited Garcetti. So when a person is speaking outside of work on their own device, or even in some circumstances on a work device, that's not a hard line. I think that their speech should not be controlled by those work policies. If those work policies, you know, not knowing the particular, this is like highly hypothetical, right?
Right.
Right. So not knowing the particular circumstances, I think that if that person is outside of work, you know, on their own time, talking about a matter of public concern, that sort of situation should get really the highest type of speech protection.
Even if there's a policy in place that states you can't speak negatively about your employer, or you can't speak negatively about the employment at all, even if it is a matter of public concern.
You know, that's getting a little close to the facts. I don't know.
Okay.
Whether the setting is whether or not the employer would just
it's, I mean, what I'm talking about here and what Garcetti and Pickering govern are only a public employer context. Definitely.
what I mean is with respect to the settings on social media.
Oh, do you know what? I don't
Is that
know.
really not
I don't know.
So are there any, you mentioned that some jurisdictions that have state laws that may grant some protections. Are there any in Ohio or County or Cleveland that employers ought to be aware of, or that employees ought to be aware of?
I hesitate to say I'm not aware of it. I mean, the thought that was running through my mind was if I was a conservative Republican owner of a business and I found out that one of my employees was running for council as a Democrat in his town, could I fire that employee just for running as a Democrat? I'm guessing he could. I'm not saying it would happen. I'm not saying I've ever run into such an employer. But theoretically, I'm not sure the political party is a protected category. And I think it would be unfortunate. But I'm not aware of, anybody else aware? There are a bunch of lawyers here. Anybody aware of any law that would bar that? I'm not. Right, yeah. Yeah, I mean, I've represented employers, you know, who have bizarre, you know, I had an employer who didn't like people who ate tuna fish. Don't tell them, I don't know why, but is eating tuna fish a protected category? No, it's not. So he wanted to fire somebody because he ate tuna fish. Hey, have at it. But I don't recommend it. You might lose a good employee. That's your issue. That's your issue. You know, I had another employer which was clearly over the, to your point about bumper stickers. While the HR people were interviewing somebody, he always had somebody go out to the parking lot to look at the car. And if the car had anything on it that indicated any religious belief whatsoever, any sign of religion, one of those little fish symbols or, you know, Jesus saves or whatever, he would come back in and say, we're done. Now that was against the law. Yeah, right. So there are employers who have issues. None of my clients. None of my clients. My clients are all well advised. I think she was successfully fired. Yeah. Yeah. Well, I think employers should be smart. They should be thoughtful. I think they should be understanding. I mean, I think you have to give employees, it's not good labor management relations to be coming down too hard on employees. I think it's impossible these days with social media not to opine on stuff. Everybody's expressing opinions on social media. I sometimes wish they weren't, but they are. And I think that's, where we live. And I think employers should have a thicker skin and, really pick their spots for something that's egregious and is definitely going to create damage and not just go off just because they don't appreciate what was said. And I think you will get in trouble with the NLRB if it at all has anything to do with terms and conditions of employment, salary, promotions, working conditions, something like that.
Yeah, I think that employers in the private sphere should strive to have an open, free exchange of ideas in the workplace. Certainly for employees who are outside of the workplace, if they see issues in the workplace based on people's expression, I think they can engage in doing trainings and taking steps to make the workplace more like the place they want it to be, and educating folks instead of firing them. With regard to public employers, I think they're compelled to be absolutist about that.
One quick thing. I mean, all of my employers are talking about diversity and inclusion, and but that's not just, to me, it's not just race, gender, sex, age, religion. I mean, to me that incorporates disparate viewpoints, and disparate political viewpoints. So it would seem to me contradictory of those goals to be diverse and inclusive if you're excluding people who are expressing things you're not happy about.
We're going to be doing this next month. Our hot talk will be on November 14th, 2017. And we're talking about human trafficking. Thanks for being here.